Max, there have been some problems in a tender for auto electrical repairs, etc., and it was highlighted in the press last week. Exactly where are we with that one now?
Okay, firstly, Johan, I must say, in terms of Section 49 of Municipal Finance Management Act regulations, it says bidders or unsuccessful bidders must be told of the outcome of the tender process, so that within 14 days, if they are not happy, they can lodge an objection. Then in return, accounting officer must then try to resolve that objection within 60 days. Okay? Now, in this case, one of contractors or service providers have then exercised that right of lodging an objection to a tender that was awarded to two contractors. Then the provincial tribunal has considered the matter. In terms of the outcome, provincial tribunal took a decision that this tender must be set aside. The municipality must then redo the process, like re-advertise. We need to start the process from scratch. That is where we are. What then I've done? I've then instructed the department or all HODs not to issue new orders now to these two service providers, because the tender has been set aside, while we are dealing with the process of us going out on tender again to appoint, because we need then to respect the decision of the provincial tribunal. That is where we are.
Have you already advertised for the new tender?
Yes, Johan, we have advertised, but it is not yet been closed. But I must say to you, the process we have now, while we have respected the decision of the tribunal to set aside the tender, start the process afresh, there is another process now. In terms of the legislation gives us powers to blacklist service providers who have submitted fraudulent information to the bidding process. We have not yet exercised that right as municipality, because we are getting legal opinion on that matter as to how best we can deal with that matter.
Okay, but now, if I have it correctly, one of the tenderers now want you to blacklist the other two, who are now obviously going to reapply for the tender.
I must say, they have not come to us directly to say blacklist them. But what has happened? This matter now is a matter of public domain. Like newspapers have published this matter, and also I had a meeting with the leadership of Ratepayers Association last week. They also told me that this matter has been raised with them. So in a way, there is a push that we must do something against these two service providers, which is correct in terms of the principles of clean administration. As the municipality, we must act against those service providers who are claimed to have submitted fraudulent documents to us. But at this stage, we have not yet taken a decision, because we are considering the matter. We are taking legal opinion on the matter.
Okay, but theoretically, if they should apply for the new tender, they could get the new tender before that process has been completed, legal advice, etc.
Yeah, you see, Johan, we are in a predicament situation, because it is not easy for us to stop service delivery now, to say when we have a broken a compactor, we cannot repair it until such time that we deal with all these issues. We're in a predicament situation, but I must say to you, we will speed up this process of finalizing our decision, get a legal opinion. We finalize our decision before we conclude on an open tender that we have advertised. That is what we're going to do.
Okay, but isn't this a critical example to show that there is a flaw or are flaws in the procurement process?
I wouldn't say per se there is flaw in our processes for this reason. Firstly, it is our procurement policy or procedure that gave right to this service provider to lodge a complaint. Is part of the process. We are told by us to say, we have awarded so and so. If you have issues, raise an issue. Not that they just, out of their own initiative, lodged a dispute. It is part of our processes that we give unsuccessful bidders a chance to lodge their dispute. Okay, that is one. Number two, I must say here, it might not be easy for us to know exactly all documents that have been submitted to us are clean. You see, it's not easy because we cannot go to all bidders' premises and check everything. So it's a matter that we are going to look, we're going to go back to our procurement procedures and see whether they have contributed to this problem or not, so that if our procedures have made a contribution, we are going to review them. We cannot dismiss it, we cannot accept it at this point in time.
Okay, but what do you guys do if your legal advice is that you cannot act against the two tenders?
In fact, the legislation provides that something must be done. So the legal advice want to, the approach, the method that we are going to employ to do it. I don't think that there is a way that they can say to us, we mustn't. Penalty, there must be sort of a penalty that must be paid for this. But I'm not saying it will definitely happen, but I'm saying in terms of legislation, it says you need to do something if someone has done things like which has been alleged to have been done.
Actually, what you're actually saying is you know there's something wrong, you just want a legal stamp on it to make it legal.
Yes, that is what I want to do, because these people may have their rights on also. They may come back and say, no, we object to what you are doing. So we want to make sure that we are correct in terms of spirit and letter of the law.
Max, thank you very much.